Notional estate. How New South Wales follow what's already been given away. Here is a plan people try in every other state. Give everything away before you die, so there is nothing to fight over. In New South Wales, that plan has a problem because we have something no other state in Australia has. I'm Adrian Corbold from Baker Love Lawyers. If you advise clients on their estate, or if you are helping someone shift assets around to keep them safe, you need to understand this because it catches careful people by surprise. It is called notional estate, and New South Wales is the only place in the country with it. Under Part 3.3 of the Succession Act, the Supreme Court can take property that left the estate before death, or that never technically formed part of it, and treat it as though it was still in the estate, then make a family provision order against it. So what does that actually catch? Assets the deceased gave away or moved before death through what the Act calls relevant property transactions. Property held as joint tenants that automatically pass to the survivor. In some circumstances, superannuation. The classic, putting the house into the joint names with one of the children, can be unwound by the court. The tidy transfer that was going to keep everything safe has a habit of turning into the main exhibit, and this is exactly why it matters for advisors. A structure that genuinely protects assets in Queensland or Victoria can be the very thing a New South Wales court reaches into. The border does a lot of work that people do not expect. It is powerful, but it is technical. Not every transaction is reachable, there are time limits, and it needs proper analysis before anyone relies on it, in either direction. In New South Wales, what you give away is not always gone. The court can follow it. So before you lock in an estate plan, or before you assume a client's gift has put an asset out of reach, get a view from someone who runs notional estate arguments for a living. Adrian Corbold, Baker Love Lawyers.